Hi and welcome. My name is Justin Mann. I am the co-founder and managing partner for Stonelink Property Management. Welcome to Inside Stonelink. Today I'm really excited to sit down with none other than Michael Crane from the law offices of Michael Crane. We are going to be getting into the 7 laws that were passed last year in the 2023 legislative session that really impact landlords, real estate investors in Rhode Island. So if you're a landlord or property owner, real estate investor here in the state of Rhode Island, you definitely want to tune into this. Michael's going to be weighing in with his expertise on these laws, helping to give some clarity, some guidance, some direction, if you will, as it stands right now. But please understand, these laws are new, they're subject to change, and so watch this space. And so without further ado, Michael, welcome to the show. So glad to have you here.
Thanks for having me, Justin.
So maybe if you could tell the audience a little bit about kind of who you are, a little of your background. If they're not familiar with you, I'd love to hear that.
All right. So I've been an attorney since 2007. Since that time, I've represented various landlords throughout the state, mainly residential, but also commercial. And, represented everyone from subsidized to private landlords, to housing authorities, whatever it may be. But it's all things housing is what I've been doing for approximately 16 and a half years. And continue to do that. And this is probably the 1 year with the biggest amount of changes.
Well, so you already stole my first question. So thanks for that. I was going to ask you, in your 16 and a half years, really have you ever seen legislation this impactful to landlords in the residential space?
I haven't, no. And it was somewhat of a surprise because some of these statutes have been, or changes and amendments, whatever you want to call, each one pertaining to each what each area may be, they've been proposed before, and they failed for whatever reason.
Right.
I think so now that they've passed, obviously, we have to abide by them. We have to follow them. Shockingly, some I know for landlords, it's somewhat of a shock,
right,
and somewhat of a gut check. But I think I think once we get over the hurdle of the lead paint issues, right, I think the other ones are not, when you dig in, are not completely unexpected or somewhat unreasonable, which a lot of people are screaming about. And I'll get into
we can get into that. And speaking of getting into it, I think the best place to start would be with the escrow account bill. And I say that because, and I'd love for you to kind of give clarity and explanation to our audience about what it really says. But the reason I want to start there is because it's happening right now. Unlike some of the other bills that passed, that turned into law, that have deadlines that are a little bit farther in 2024, this is here, it's now, and I believe there might even already be some case law. So maybe you can give kind of a brief rundown of what the law says, the impact of it, if you will, a description of it. That would be terrific. And then we can, maybe get into a little question and answer about that.
Absolutely. So let's take a step back. Let's realize there's always been an escrow account law on the books.
Fair. Okay.
Okay. Because if you are a tenant, you're not supposed to withhold rent if there's damages to your property. You are always supposed to go and you could petition the court or file a case against the landlord.
Right.
Now the problem is, what tenant has the money
right.
to go down and do that, or the time? So they withhold rent. So the landlord's the one that files the case, which is a non-payment case, and then you get into court. But when you get into court, you either have to have all the money in the bank or put it in some sort of escrow account.
Okay.
So there's been some sort of escrow law in the books. The problem is, recently, I think it's also because maybe we're so far from 1978, there just hasn't been a lot of lead work done by landlords in the last 5 to 10 years.
Fair statement.
And right. I think the legislature picked up on that. And I don't know exactly if the number of lead poisonings have increased. I don't know the answer to that.
Yeah.
But what they're looking for is some teeth to finally get landlords to comply. And probably one of the reasons is, if you think it through, the AG may be tired of getting calls on non-lead conforming properties. So let's get properties conforming. How do we do that?
Right.
So first thing we can do is, where are you going to hit landlords the hardest? You're always going to hit them in the pocket.
Wallet. Yep.
Right? Every time.
Every time.
So why not say a tenant can come in and petition the court and place this money in an escrow account that is held by the court? So it's just the court registry, the generic court registry. The court has done a very good job of improving the court registry. Okay. So money comes out of the registry really quick.
Okay.
It doesn't just sit there.
I'm going to have a question about that in a minute, but yeah.
Yeah. So you go in, you're a tenant, you petition the court, you say, hey, You're right in front of me, so I'll use you. Justin Mann owns a property. He doesn't have any lead certificates.
Yeah.
I pay $1,000 a month in rent. I want to put it in the court registry until he gets a lead certificate.
Okay.
No date, no start date on that. It just comes into effect January 1st. So that becomes the de facto start date.
Right. So it's in effect right now.
In effect.
Okay.
Haven't seen one case on it.
So there's no case law. That answers my second question. I thought there had already been one before the court that had come up.
Not that I've heard of.
Okay, fair enough.
So, and I have communicated with the clerks and whoever. Hey, listen, if one of these comes up, let me know.
Yep.
So haven't heard of one yet, and we're waiting for that first one because really what I want to see is how is it going to be interpreted? Is it going to be interpreted that they're going to open the floodgates and allow for all of these rents to be escrowed in the registry?
Yeah. Or
are they going to wait and say, listen, there's a law in the books that gives landlords until October 1st, which we'll get into later, to comply,
right?
And to have these lead certificates to be able to file non-payment. So I'm going to wait till October 1st.
And yet, on January 11th, we did have the guidance from the Attorney General saying, "Hey, the way we're reading this thing, it's in effect right now. So welcome to 2024. Hope you had a great New Year. You need your lead conformance certificate, and if you don't have it, then your tenant has the right to petition the court, file a motion to deposit their rent into escrow." That's their interpretation.
Correct.
That's their guidance, but that's not how the courts, it's not law. It's not what the courts have come back and resonated and said, yeah, we agree. We don't know. That's kind of the bottom line first. We don't know because there's no case law.
Correct.
So just from a kind of a flow standpoint, so the tenant can check, and there are it's public available database on whether or not there's a lead conformance certificate for the property that they're living in. And if there isn't, they can file a petition with the court to deposit their rent into that escrow account.
Correct.
Here's a couple of follow-on detail questions though. What about additional charges? Like, let's say I'm living in a house.
So that's where let me get into that. So you can place the rent into escrow.
Right.
Now to bring the property up to conformance,
Mm-hmm.
now the tenant could take action. The tenant could obviously call on behalf of the landlord, and there's costs of filing the suit to put the rent in.
Sure.
There's costs of if they had to hire an attorney to help them, all of those things. So $1,000 goes in.
Right.
Let's say $1,000 goes in, they go out and get the lead certificate in 2 days.
Yep.
Landlord would get $1,000 if minus any costs.
Okay.
So the cost could be the filing of suit, $104.02, service, which is usually about $45. So maybe minus $150. Let's just keep it simple.
So there's going to, bottom line first, there's going to be a cost to a landlord if that money ends up in an escrow account, full stop.
Correct.
Some amount,
I would
we
say
don't know how much.
$150 minimum.
Okay.
And then, one question I get from the landlord is, well, does that become a non-payment case, the $150? No, it doesn't become a non-payment case. You lose the $150 for them having to file suit.
That's your penance for basically not conforming.
Exactly.
Okay.
So, but if there's no costs, let's say they were indigent and they filed a motion in form of pauperous, so they didn't have to pay a filing fee. I know that's getting a little legal, sorry. But let's say
we're going to need a dictionary for this, but go ahead.
But they don't have to, let's just say they don't have to pay a filing fee.
Okay,
right?
Fine.
So then maybe there are no costs.
Right.
Maybe you get the full $1,000.
Right.
But you can't, but you can't send the non-payment letter. The registry's open, non-payment cases are off the table. Excuse me, termination cases are off the table.
Yep.
Why are termination cases off the table? Because you have retaliation.
Right.
If they filed it and you don't have a certificate, that's a clear-cut case of retaliation. So what I'm saying is, let them file it, put the money in the registry, get your lead conformance certificate. You're going to get that money minus any costs.
Okay, so I'm going to, a couple of questions for you. So again, so they paid the rent. Let's just say they paid their $1,000 for the rent. But let's say they're also responsible for utilities, and maybe it's a house and they're getting back billed by the landlord. And so that's also in the lease, so they're responsible there. I guess my question is this: any additional charges that are part of their lease agreement, did those also get paid into the escrow account?
I would argue no. That
Okay.
if it's utilities, they've got to pay to keep the utilities on.
Okay.
They've got to pay. Now, if it's rent utilities included,
Right.
you're going to be out of
No,
luck.
that I get. Totally get. But there are sometimes broken out line item charges per the lease agreement that are like, you're responsible for this, you're responsible for this, you're responsible for this. Rent is this, but then you have a pet fee or whatever else is included. Those would either go to the landlord or to the third party, whether it's Rhode Island Energy or whoever we're talking about.
I would argue yes, they would.
Okay, I get it. We haven't seen what this really looks like. Next question that came to my mind is, what happens if you have a resident in this situation? They petition, they're putting money into the escrow, but now they're behaving badly. So now we're in a non-compliant situation. They're in violation of some part of the lease agreement. Maybe they're getting into fights regularly with their neighbor or whatever the case is. But under normal circumstances, escrow account aside, this would be a non-compliance case. What, if any, action can a landlord take in that situation?
Well, you can always send a non-compliance letter.
Okay.
You're
not devoid of that right. They haven't taken that away from you.
There's never been a situation outside of the CARES Act during the pandemic which said certain non-compliance letters couldn't be sent, that you can't send a non-compliance letter. And the CARES Act really only applies to subsidized housing providers.
Okay.
And
it's kind of very
with
specific.
federal mortgages, yeah.
Okay.
But that wouldn't apply in this case. You could always send a non-compliance letter.
What does the court do if they stop paying rent into the escrow account?
Well, that's going to be the ultimate question. That's what everybody asks.
And first of all, is somebody watching?
You can't file a non-payment. Yeah, you're not going to be able to file. It's going to be hard to file a non-payment case after October 1st, even if they stop paying rent into the escrow account. But I think if it's between now and October, I think that's going to be a problem for the tenant. Like, where's the money? What are you doing?
Right.
This is a non-payment case. They don't have to file it without a lead certificate, so they can go forward. But I think the court should allow them to go forward until any filing after October 1st.
But it's all kind of TBD because, of course, we haven't seen where the rubber meets the road. We haven't actually seen any case law. We've never had this before the judges. We don't know how they're going to react, what they're going to rule. And I presume, circumstances are going to be different for everybody. But again, we haven't seen it, trying to war game out where are some of the issues that could arise with this. What about things like late fees? If it's in the lease agreement and they're supposed to pay by the 5th and now it's the 6th, and let's say they're paying into the escrow account and they pay on the 9th, and normally a late fee, if per the lease agreement applies, can a landlord expect to charge and be paid for a late fee?
I would say you've got an active case that would probably be subject to a judge's decision. You can always ask for the late fee. Okay. But whether you get it, I wouldn't guarantee you obtaining that late fee. You'd always ask for it.
Sure.
You'd always demand it. But you've now got an active case. So the ultimate decision maker is the judge in this case of who's going to where they're going to release the money, how they're going to release it, where it's going to go, and what charges are going to be imposed on both parties at that point.
Right.
How much rent are you going to owe? How much are you going to reimburse them in costs? And then any fees associated with the landlord-tenant relationship.
And I don't want to conflate things here, get too far ahead of it. And we're going to talk a little bit about the self-help repair limit increase, so on and so forth. But I have a little bit of a tendency to want to apply experience here and say, in a normal case where there was an issue that needed to be fixed within a property, let's say it's not lead, the landlord is typically given about 20 days or whatever the case was to repair that issue. It doesn't sound, though we can't answer right now, as if the court may even give the 20 days. They may automatically allow them to deposit rent into the escrow account. You can still go get it fixed in 2 days, but there is no stay. There is no kind of grace period, as it were, to allow the landlord to remediate the issue without the escrow account being established.
No, it would be an immediate deposit into the escrow.
That really answers the question. All right, well, I think, we've covered. Is there anything you've run into, any questions that you've had that you maybe want to share from a Q&A standpoint? Because I know you deal with landlords, real estate investors all over the state. Be curious to see, what you've been fielding for questions if I've missed anything.
I think we've kind of hit on it. It's really the questions revolve around, how can I get the rent back paid? What happens if they don't pay? What happens if they pay late? And what happens if I just never conform? And then also, what can I file to get rid of them if I really want to get rid of them?
Okay.
And we've kind of touched on all that.
Yeah, I think we've covered that. I think we've covered that waterfront. But it all kind of leads to the second law, which has to do with lead conformance certificates being required, deadline established. We're going to get into that. But I mean, this really stems from even the rental registry, as it were, which we'll talk about in a little bit, also orbits around lead conformance certificates, which for people that didn't see our first episode, we established that lead conformance certificates aren't new. I mean, they've been on the books since 2005 really is when it came down and said, yep, everybody, residential real estate had to have lead conformance certificate with the exception of owner-occupied properties, correct?
2 and 3 families.
2 and 3 families. That has gone away. We can touch on that. But the point I'm trying to make is lead conformance certificates have been around for years and years and years.
Yes.
What really transpired last year was enforcement with teeth. I mean, that's the way I'm kind of looking at this.
Absolutely.
It's like, yep, lead certificates were on the books. Now we're going to really make you go get them. So let's talk about kind of law number 2, as it were, where where it's requiring lead conformance certificate with penalties, with a deadline, with ramifications that never existed before. And I would argue authority for enforcement has been now given to the municipalities. Is that a fair characterization?
Well, municipalities always had authority for enforcement. I'd say more it's given to the Attorney General.
Okay.
Which
fair.
had some enforcement as well. This just really clarifies it.
Okay.
Really keeps it clear for the landlords.
Okay. So let's talk, maybe you can kind of give a brief rundown on what this law really says, just kind of the nuts and bolts of it.
So really the penalties and what the law says really comes out of the rental registry is what it comes out of. So really we should address it. I think
we can talk both at the same time.
We'll do them both at the same time.
It's hard to talk about one without the other.
Correct. I would start with the rental registry and then work its way.
Fair.
Kind of work your way down. So the rental registry is what it is. So pending the available funding being made available by June 26th
Which
of this
is still
year.
in question.
Correct.
Okay.
But we've got 6 months. So
Yeah. They'll find the money somewhere.
Correct. So as long as the funding's made available by June 26th, by September 1st, Department of Health is supposed to have a landlord database
Right.
that has been created that you can go in and you can register all of your units. So why do I say units? Because if you have a 3-family, you have to register each unit individually is how it looks and how it looks like it's being written.
Okay.
So
including the property address. So 123 Main Street, then 123 Main Street, Unit 1, Unit 2, Unit 3. So
correct.
Technically that 3-fam would have 4 entries.
I would say 3.
Okay.
It'd be 123 Main Street, Unit 1,
Okay.
Unit 2, Unit 3. So you put all that in there. You have to put in there who is managing the property.
Yep.
Or if it's you put you. Then you have to put in your own personal information.
Okay.
And then you put in the information of the management company or who's ever managing the property.
Okay.
So 1 and 5 kind of say the same thing, kind of don't. But I'm sure that's how it, I would think in looking at it, that's the information you're going to have to provide. You got personal address, email address, phone information. You have to keep it updated. And basically, you have 30 days to register the property until October 1st of 2024. Once October 1st comes, not only do you have to have the property registered,
Right.
but you also have to have a lead conformance certificate uploaded for each individual unit.
Right.
Now, you can go and you can have your whole building inspected, and units 2 and 3 can fail, so you might only get a certificate for unit 1, but unit 1 is uploaded, it's there. But then you got to work on 2 and 3. Now, there are penalties that apply if you don't register on time. So you have to register your unit on time. If it's pre-1978, you're going to have to provide your certificates. And if not, it's $50. It could be a $50 fine. And then if you don't have your lead conformance certificate, it's up to $125.
And that's
fine.
per unit.
That's per unit.
Right.
So you're looking per month.
Right.
So you're looking at a $370. If you have a 3-family, you could be paying a $375 fine per month.
Now,
possibly.
to be clear for our viewers that are watching and want to understand this, there are 2 dates. You've already talked about them, September 1, October 1. September 1 is related to the rental registry. You got to get everything uploaded there. October 1 is you also have to get your lead conformance certificates updated. Let's say you missed the window for rental registry September 1. Here's where my question is. When do the penalties kick in?
So that's a great question because there's no
Can I get a great answer?
I don't know. I hope so. There's no real explanation because the way I read it, I mean, if I owned a property,
right,
come October 1st, 2024, and I registered it October 5th,
right,
or let's say I registered it December 1st.
Right.
December 1st is probably a better example. Is there an automatic $100 penalty because I didn't register it for 2 months and it's a $50 a month penalty?
Right.
And I'm running in there, I've owned it since 2015.
Right.
So I owned it for those 2 months. Is there an automatic penalty? Like, how is that going to work? Is someone going to review it behind the scenes and then impose the penalty? We don't know how that's going to work. We don't know what type of enforcement is there, but it is an enforcement through the AG's office. So really, there might have to be some sort of due process. So it could be you get a notice in the mail that says, hey, listen, you didn't register your property. You could be subject to this, $100 fine.
Right.
Right. So, but you can contest it, and this is how you can contest it. So those are things that all are going to have to work themselves out.
Now, correct me if I'm wrong. The Department of Health is part of this.
Correct.
Okay.
They're the overlord.
They're the overlord.
overseeing.
But to your point, the Attorney General also gets a say. They have a dog in the fight. They're
the
more teeth.
enforcement arm. Department of Health oversees it,
Okay.
and then the Attorney General comes in and they're the enforcement.
I was looking at it, speaking specifically to fines and penalties, right? So the Department of Health has fines and penalties, as it were. but does the Attorney General not also have additional
No,
fines?
so the Attorney General is the one that would enforce the fines
Okay.
and penalties.
Just want to
that are
clarify that.
imposed.
All right.
Yeah.
Because there's a $1,000 and then a $5,000 fine based on.
Well, that's if you just
So let's walk through that.
completely
Maybe
blow it
explain-
off.
Yeah.
Then you could have these other additional fines and penalties imposed.
Okay.
And that's really when you'd have some concerns. And I think that's really when the Attorney General would get involved.
Okay. And just to be clear for the for the viewers that are watching, maybe run down, when does the $1,000 and the $5,000 fine kick in? What are the
So they would
circumstances?
their kick in, if you don't mind, I'll grab the
Sure.
statute just because they're
Yeah,
brand
please,
new.
by all means.
So if you look here, they may commence an action against you for injunctive relief.
Okay.
So basically, if you don't do anything and they have to go to court and file injunctive relief, which
Right.
a lot of people call restraining orders, they may known, that's all falls under the umbrella of injunctive relief.
Okay.
If they have to do that to force you to get your lead conformance certificate, to force you to sign up for the rental registry, then you could be looking at $1,000 per violation for repeatedly failing to comply with.
And there's
the
a
requirements of the
$5,000 if they're not, if they think you're like an egregious repeat offender.
Correct.
If you're a really bad individual and you really are thumbing your nose at
Yep.
the state saying, I don't really care what
Yes.
you have to say, what you're going to do, what are you going to do about it? They're like, well, we're going to slap you with some pretty hefty fines. So
Exactly.
maybe we'll get your attention that way.
Yes.
Okay. Great. Got it. Fair. So this is really about starting with the rental registry, which, as you said, is kind of all tied together.
The rental registry is the easy part. The
Yeah,
hard part
agreed.
is,
We'll get into the hard part
when
here.
was your building built?
Yeah.
And do you have a lead cert?
So the question that I have on the rental registry, just before we leave that topic, is, and I think you've already answered it, but I want to be really direct about this. So I have an LLC. The LLC owns the property. Can I put the LLC information into the rental registry, or do I have to put my personal information into the rental registry, including like my home address or what? There are some concerns about privacy, retaliation. Some landlords might be genuinely concerned about, hey, gee, I don't necessarily want to have my personal information within this public database as owning 123 Main Street. So if I have an LLC, can I use the LLC? Can I use the LLC's address? Or even,
So that's a simple one. The good thing is they thought that through. You can
Yeah.
put a business address, PO box, or home address. So they do allow you even a PO box in
perfect.
there. Whatever you feel is best and makes you feel safest, that's what you can put in there.
But you got to put your name.
Yeah, you got to have a name in there. You got to have a contact person. You got to have. It's like having a registered agent.
Okay.
Is what it is.
Fair enough.
You got to have a registered agent to be able to serve, contact, do whatever's needed to be done for that property.
Could my attorney be my registered agent that I put in there?
It could be, but you're going to want also the personal. You're going to want your personal information. They're going to want that in there so they can contact you.
Okay.
In there, and I will tell you this: love you to death, love everybody to death, all my clients to death. I wouldn't do it. I can't even do the registered agent.
That was going to be after this, just so you know.
Yeah. I wouldn't even do the registered agent I don't do it for landlords as well. And the reason is the amount of mail that we get.
Yeah, you're going to get.
We
you
couldn't
keep up with it.
We wouldn't be able to keep up with it just because of everything that kicks in. And not just that, all of the junk mail that kicks in. You probably know, but just that amount would add an hour, 2 hours of work a day and take away from everything.
There's also the issue of, gee, I hope we don't miss a notice, or I hope something doesn't slip through the cracks. And it's not, there's a lot of room for error there.
Correct.
So speaking very selfishly here, right? So I have a property management company. So our client needs to register. We've talked about that. They have to identify us. They do it or we do it as far as uploading our information to the rental registry as the property manager, in addition to their personal contact information, whatever that may be.
So if it was me and I owned a property
Right.
with the penalties that are attached and everything going on with the environment, I would want to go in myself and enter the information to be safest.
Right.
Because I would want to make sure it's on there properly. But not only that, you never know what's going to happen.
Okay.
So you want to make sure that they can contact you. Because what you don't want is you don't want your mail to get lost somewhere, and then all of a sudden it ends up at a property management company.
Right.
And let's just say you move to 123 Main Street from 15 Circle, right?
Right.
So what if the mail accidentally goes to 15 Circle, doesn't get forwarded?
Yep.
Now they're at 123, but now the mail at least is coming to you. There's no harm in receiving that mail and forwarding it to StoneLink and saying, hey, I got this. It needs to be taken care of.
Right.
I know this is what you do, but I wanted it to come to me just to keep everything safe.
Because at the end of the day, it's the owner of the property that's going to be subject to those fines and penalties.
So
Or is the agent as well? Can the property management company be subject to fines and penalties?
The way this is defined, the property management company could be subject to those penalties and fines.
Okay, so now I'm going to flip the script on you and say, wait a minute, hold on. As the property manager, I want to make sure this gets entered properly, because if I'm going to be liable for subject to fines and penalties, just like you were saying with the property owner, we're kind of both on the hook, as it were, right? So I kind of want to get that information entered just as much as they do, right?
Correct.
Okay.
Yeah. No, that's
so.
A
do
great
I have
point.
any control over that as a PM, and for any of the other
Absolutely,
third-party property managers?
You could go in and look at it, and you might want to go in and verify that all the information is correct, that your information is correct.
Okay.
Review your, obviously this is, crazy. You review your property management agreement for each individual owner, like who's responsible for this, where are the liabilities, where's the indemnification, all of those things.
Got it.
As a property management company.
There's a lot to cover there, but I think it's a good way then to segue into what the rental registry really speaks to is the lead conformance certificate, because at the end of the day, that October, like you said, September 1, okay, I think we're all big boys and girls. We can figure out how to enter our information into a rental registry, assuming this thing gets funded and it's up and all that happiness happens, right? But the lead conformance certificate is a whole nother ball of wax, because there does require action there. And there is steps that somebody needs to take, assuming they don't have a lead conformance certificate. And while we had already gone into, in a prior episode, kind of the practical steps that have to happen to get a lead conformance certificate, maybe you could speak a little bit too from a law standpoint, from a legal standpoint, from a language standpoint. What is it really saying about the lead conformance certificate that hasn't already been said?
So there's nothing really that is being that hasn't been said. It's just the requirement that you should get it.
Okay.
It automatically gets uploaded into a public database once you get it. So you can grab the certificate and you can load it into this new database. But there's no additional requirements that I know of, or that in the lead inspectors I've spoken to, you really have to talk to a lead inspector. That's kind of my, caveat. Don't listen to me about whether you need a lead certificate, whether it's going to pass, fail, whatever. So go out and do that.
So on that note, for everybody that missed it, our first episode was with a lead inspector. We walked through the whole process. So if you missed it, please tune into that. Back to you, sir.
But really, there's no, besides the change that now, if you're an owner-occupied 2 or 3 family, you have to get lead certs for the units that you don't reside in. There's no changes to obtaining a lead certificate. You just have to do it.
Right.
That's the thing now. Now that, like you said, there's a little bit of teeth, there's a little bit of meat in the laws with these penalties.
So a couple of questions that come up, right? We deal with a lot of clients. First question, here you are. I'm a landlord. I don't have a lead conformance certificate. Can I still rent my unit without one?
You can rent it, absolutely. Okay. But remember, when you rent it, you're supposed to provide all the lead disclosure information as well.
Right.
So
it's yes, but.
Correct.
And that you really are, I mean, let's be candid. You really are opening yourself up to issues, because obviously getting a lead, well, I say obviously, if you don't know, getting a lead conformance certificate on an unoccupied unit is a heck of a lot easier than getting it on an occupied unit, right? Because if you have to go in there and do remediation and cleaning and all that happy stuff, it is much easier to do when there isn't a human living in that space.
Correct.
So if you were to let somebody move in and they, do so without a lead conformance certificate, you're really opening yourself up to liability from day one of moving in.
Not just liabilities. I mean, what happens? They give you first and security. Right. Month 2, they say, "Oh, guess what? Where's your rent money?"
Yeah.
It's in the registry.
Yeah.
What do you mean it's in the registry? Well, I knew you moved in and didn't have a lead cert, so my money's in the registry.
Right.
Okay, now you've created that headache, and that with the amount of information that's going to be out there related to these statutes, probably not a risk you want to take.
Right.
Especially now. Everybody's on it. The lead inspectors are on it. There's additional lead inspectors out there. You can get this done now.
Yeah.
And you can get it done probably rather efficiently.
It would be fair to say reckless, if not just downright bad decision-making to try to do so.
Absolutely.
Okay. And for the audience, it's important to understand these lead laws exist for a reason. We want to keep people safe and we want everybody to have, good health. Lead poisoning is a real thing. It's happened. It's happened in this state. I don't think Rhode Island actually as a state has a great track record, as the case may be, as far as lead poisoning is concerned.
It doesn't, which is probably another reason behind these.
So it's no shocker. So, before conformance, before legalities, before, compliance and all that kind of stuff, at the end of the day, the lead certification is designed to keep people safe. I mean, let's be very clear about that.
I've had cases where they come in with elevated lead levels and you see it, and you see the kids, and it's sad, you know? I mean, you're talking 1, 2, 3-year-old kids who, you know, need 4 or 5 years now to recover.
Right.
And, you know, now they're in 4th grade. So, I mean, it's a good thing. It's not a bad thing to do.
But where the rubber meets the road is obviously there's always questions that arise. Here's a question that we did have. By having a lead certificate, does this help from a liability standpoint if, God forbid, there was a lead poisoning claim within that unit? So I've got
that may that's a question for a bigger lawsuit. If someone brings liability, it may. But let's say you're supposed to get a lead certificate every 2 years, right? So you live there for a year, then I move in, and on your way out, you decide to drag things out, and it drags across a bunch of windowsills or something like that.
Right.
And now all of a sudden you've exposed lead paint, and the next person comes in and just takes over. You're the owner. You do a walkthrough. You see it. You know what? If you can live with that, I can live with that. Now lead paint's exposed or whatever it may be.
Right.
You know, so you don't know. Every situation is unique and different. So
fair.
Anytime you speak of liability, you have to be very careful.
I want to be clear about this. You just spoke to it, and your example, I think, is a great tee up, and we didn't even rehearse this. If I get, so my lead certificate is good for 2 years, right? If in the process of that 2 year, you know, the resident moves out after year 1, and I have a new resident that moves in year 2, right? Or, you know, at the end of year 1, if you will, my lead certificate is still good within that 2 year period.
That's what I've been told. Yes.
Okay. Now we do know, based on our understanding, that if the same resident remains in place, you can renew that lead certificate in perpetuity, and you can actually do kind of a self-inspection at that point. However, if, and again, I'm not an attorney, so I'm bouncing this off.
Well, I'm not a lead inspector, so that would be
fair.
Right.
But as we understood it, if and when that resident moves out after the 2 year period of time, obviously you're going to need to get that re-inspected. Okay. As you mentioned, you can get a lead certificate, or they legally can issue a lead certificate for 1 unit in a 3-family if the other 2 fail. It's not an all or nothing thing.
No, I do know that I've had lead certificates issue on specific units and not other units.
Okay. So let's say you have, what guidance would you give? And I'm sure you've had these conversations. You get pushback from one of your clients. They're a landlord. They own a 3-family. Like, Michael, I don't want to do this. I'm just not, my property's fine. I take great care. I clean that thing like, you know, I have OCD. This property is great. I don't want to get a lead certificate. What's your response to that?
Doesn't matter.
Okay.
Because pre-1978 building doesn't matter. You have to have it.
Okay. That's it. Bottom line.
It's that simple.
Yep.
Yeah, I mean, you could sit here and argue. We can talk about it.
Sure.
Till we're blue in the face.
But at the end of the day,
it's not going to change the law. It's not going to change anything. You can be frustrated. There's nothing I can, and when I say you, not you.
Yeah, no, I get it.
Over the phone. There's nothing we can do about it.
Okay.
At that point.
Now I'm going to ask a selfish question from a property manager standpoint, not just for myself, but for other property managers out there. If they have a client that refuses and they put them in touch with somebody like you, super smart, knows the law, explains to them, hey, you don't have a choice in this matter. You got to get this done. And for whatever reason, that client still refuses, what exposure liability does that property management company, that third-party manager, have if they are working with a client that refuses to get a lead certificate?
So first, I mean, you go back to the liability question. You'd have liability for any injuries, personal injuries.
Sure,
first,
which would include lead poisoning.
Correct. And then you could have you could have the monthly fines. You could have, you could have the injunctive relief fine. You could have all of that come down and be imposed on you.
Okay.
The lucky thing is you're a property management company, so you can send out information or have them sign something that says, listen, we don't agree to do this. We agree to indemnify you, all of those things. Now, even though they're agreeing to indemnify you, that means you pay it out of pocket and chase them. So, that becomes a business decision.
Right.
How much do you really want to work with that individual? How much do you want your name tied into that individual?
To say nothing for the fact that, again, you want people to be living in a healthy, clean, and safe environment. Not really interested in, entertaining anything other than that. We've seen situations, or hypothetically, if you could say, you have a tenant that doesn't want to either allow access to get the lead conformance certificate, which starts with an inspection and then goes on and on and on from there, right? Or they do allow access, but for personal hygiene / living condition reasons, it's not physically possible to really clean, let alone test, let alone remediate, or take any of the steps necessary to get that lead conformance certificate. What options does a landlord have?
So really injunctive relief.
Okay.
We go back to that. So you really want to go down, file some sort of restraining order, one for access.
Okay.
Excuse me. Two, to force,
I'm putting you to sleep.
I know.
I'm sorry.
No, it's not you. To force the resident to clean up.
Okay.
To make their unit, to bring their unit to a condition that allows you to make these necessary repairs.
I don't want to make any assumptions, but I'm going to do so right now. Could I assume that if we went through injunctive for relief, we got access, we got a court order to force the resident to clean this place up, to allow for remediation to happen, so on and so forth. I would like to assume that that same resident couldn't turn around and then file to have an escrow account established because there isn't a lead certificate on file, because that's the action you're already working towards. I don't know if you can answer to how the court would interpret such a motion.
I don't know how a court would interpret that, but I would have a hard time with a court saying, this is the landlord's fault, you can put this money in escrow.
Right.
I think the court would say, you know, you're the one that's forcing this. We have pictures of the conditions. We have everything going on. Remember, the escrow account is at the court's discretion.
Right.
So they can deny that petition.
Okay. All else being equal, from what I understand, again, no case law is, out there yet, so we don't even know how they're going to handle it. But it sounded like if it was a pretty straightforward situation where you had a good resident, but they went online or they found out that there was no lead conformance certificate on file, and they went and petitioned the court, filed a motion, say, hey, listen, I'm living in a place that doesn't have a lead cert. I want to establish an escrow account to force the issue. That's probably going to be like a light switch for the court. They're going to be like, yep, you're absolutely right. We're going to do that. Escrow account established, rent goes in it. Mr. or Mrs. Landlord, you need to get this lead cert and come back and see us when you've done it.
Correct. Great example just popped in my mind, the Superman building. They want to say they want to make it all residences, right?
Okay.
Let's say they turn the whole thing into residences, down to the studs. But the exterior may have some wood on it.
Right.
So we all know I think it's pre-1978.
I'm pretty sure.
Yeah. So they would need lead conformance certificates, right?
Right.
So let's say they don't get them. Let's say they open it up, all the residences. And then the second month, all the residents go down and petition the court.
That's a pretty big rent bill that's not going to the owner.
Correct.
Yeah.
Yeah. So those are that's how extreme it could get.
But again, it's all hypothetical right now.
Correct.
Okay, fair enough. Let's move to something that I think, unless you have anything else you want to add on the lead conformance. No. Let's move to something I think is a little bit more straightforward, but hey, it's the law and it's nuanced and open to interpretation. Banning of application fees, right? So this smacks very much in line with the current administration's junk fee kind of initiative, if you will. I don't know if it really is tied into that, but there was a law that was passed 2023, banning of application fees. Maybe we can speak a little bit to that.
So we'll do the old, like I say, take a step back. Why did this come into effect? This came into effect because a lot of mom and pops realized very quickly they could make a lot of money off application fees.
Really? Right.
And so what they were doing was they were charging $50, $75 to 100 applicants. Do the math, right? So you run all those background checks.
It's probably more than their rental income on the property.
Correct. And they're not running all those background checks at all. They're probably going onto the court portal, typing in so they can say they did something, and that was that. So you're making a quick $7,500 off an empty unit. And there are people who were doing that. So the banning of application fees, you're still, and I understand you're a property management company. So when I say out-of-pocket costs are different for everybody.
Sure, of course.
Right? You're out of pocket. You're like, I'm paying somebody to run this.
Right.
So that's an out-of-pocket cost.
Right.
But really, it's just these specific out-of-pocket costs for the background check, for the landlord verification, for the credit report. Those costs, whatever they are, tenant has to pay for them. Resident applicant has to pay for them.
Okay.
Unless they have a copy that's been issued within the last 90 days. If they provide that to you, they don't have to pay for those costs. Okay. You can still run them. You can still request to run them. You can still say, listen, we have to run them to verify what you gave us is true.
Right.
But they don't have to pay them.
So let me push back on that a little bit. And I wonder how they'll interpret this, because not all background checks are created equal. There's different companies that have different standards, that provide different level of detail, go back a certain amount. if the applicant provides a BCI and credit report, let's say it's within the 90 days, but it provides nowhere near the level of detail that either the property manager is able to attain or the landlord owner of the property is able to attain, can they still charge to run theirs if they can demonstratively prove like, hey, you gave me this, which is like a C grade level background check, and this is what we require, which is an A grade background level check. Is that an argument that could be made?
Absolutely.
Okay.
I think it's an argument that eventually has to be made.
Okay.
Because I'm sure there's probably some company out there, ready, because we're not the only state with this law.
No.
So there's probably, if there isn't a company already, I don't know of any, but there's probably a company ready to say, listen, I'll provide you C-level background checks.
Right.
At the cost of $20.
Right.
Instead of having to pay $65, which are the out-of-pocket costs.
Right.
And you can have this, and it's, for 90 days, and you can renew it for $10. And
so they're really at that point, that hypothetical, that mythical company, assuming it doesn't already exist, would really be targeting those applicants saying, hey, listen, just sign up with our service for the low subscription fee, because everybody loves an annuity as a business, right? For a subscription fee, we're going to be able to, generate these things on an as-needed basis, and it's a cut rate, bare bones. But as a landlord, you don't want bare bones. As a property manager, you don't want bare bones. There are very thorough background checks, but they cost money because, you're accessing databases and so on and so forth. So I think you've kind of answered that. If in doing so, I guess the question I would have is, what can a landlord charge for, if anything, beyond, and I'm going to give you an example before you answer, if anything beyond the actual cost of the BCI credit check. I'll give you an example. We've all been, if you've ever applied for a passport, right? And all of a sudden you just plan horribly and you're leaving on a plane in 3 weeks and the normal processing time for a passport is 4 weeks. You can, full disclosure, I've done this, pay an expedite fee to the United States government. And they're like, hey, for the low fee of an extra $100 plus $50 for the overnight shipping, we'll expedite your application for your passport or your passport renewal, and we'll get that thing to you. No guarantee it gets to you before you want to board the plane, but you're far more likely to do so. And if you're in that situation, you gladly hand over the $150 or whatever the cost is. Is it legal for a property manager or a landlord to offer an expedite option for an applicant separate from the BCI credit check? Just throwing this out there, saying to an applicant, listen, I understand you're in a hurry, blah, blah, blah. Our normal processing time is this. If you want it to happen faster, we do offer that as an option, but there's a cost to do so because I've got to employ some more people. I got to pay them extra time, whatever the case is. It's hypothetical, but I want to throw it out there because, there are overhead costs for doing this are different for everybody, right? If you're a mom and pop landlord and you're just kind of doing this on your off time or whatever, your overhead cost is X. If you're a property management company with staff and you're paying people to call prior landlords and employers and all this kind of stuff, your overhead costs are going to be more. And so you have to figure out a way to balance that.
So I think that's good. With no case law, it's a good question because how would that, we would say, listen, it's not a rental application fee.
No.
We're just expediting a decision. We're trying to get them housing quicker,
right,
whatever it may be. And then the other side's going to argue, well, it's really just a hidden application fee because who isn't going to pay that because they're going to want the unit before other people. So you've got competing arguments, and who knows where that would fall.
Yeah.
I think it would depend what judge you're in front of.
Okay.
For sure, on how that would fall. Do you have a pro-business judge or do you have a pro-resident judge?
Right.
And I think that's where the decision would fall.
Okay. Do you see any other pitfalls, landmines, or otherwise holes that landlords, property management companies should be aware of around this, or is it pretty much we've covered the waterfront?
Fraudulent reports.
Okay.
That's the biggest one, which I think everybody is.
That's a big thing, as far as fraudulent credit reports, yeah. And there's a whole thriving market for that.
Yeah, once people get upset about the not being able to charge application fees, the next thing they go to is, what if it's fraudulent?
Right.
That's why the last section exists.
So the next law I want to talk about is this: sealing of eviction records, right? So nobody wants to get a fraudulent application because it can lead to bad behavior, ultimately non-payment of rent, ultimately an eviction, and that costs money and time. And really, landlords and property managers don't want to evict. They want to get good residents that are going to stay and pay the rent on time and take care of the property. If all of that goes sideways and the train goes off the tracks and eviction does happen, now we have a new law that says, wait, okay, you evicted this person, but now there's a law that says we can seal eviction records. What are the circumstances under which that can happen? How does that really kind of play out, or how do you think it's
So
gonna
really
play
it's
out?
for non-payment cases.
Okay.
I mean, it's really, it doesn't apply to all cases. It applies to non-payment. I think it can apply to non-compliance cases, but doesn't apply to termination cases, where basically 30 days after the appeal period is 5 days. So if we went to court, let's use Tuesday. I always use Tuesdays and Mondays.
Okay, you like
Why?
Tuesday.
You know why I use Tuesdays and Mondays?
Tell
Because
me.
5 days is the weekend, so you also get Monday to appeal.
Okay.
So, let's confuse the people. So let's say, your appeal period is 5 days, but really it's the Monday.
Okay.
So 30 days from a Tuesday,
Yep.
you can petition the court and say, I want to seal this. I complied with all the terms in the agreement,
Mm-hmm.
so I want to seal the eviction. So you can only do one in a 5-year period. I
Okay.
think it's 5-year period.
So if you're a repeat offender, this
Yeah.
isn't going to help you.
If you're a repeat offender, maybe you have 10 evictions on your
Yeah.
record, you can seal one of them.
Yeah.
Pick and choose which one and go from there.
Right.
But really, if you're the one person that just hit hard times,
Yep.
that had certain issues here or there, you can get that sealed. And you do run into that. You do run into a couple who, successful couples who are just like leasing in between houses.
Yep.
And all of a sudden it was like, oh my God, we were just in between houses. He got laid off, and now our $4,000 a month rent. Whoops, we couldn't afford that.
Couldn't cut that check.
Yeah. So, and they're there, or you have the mom and pop who, they're making minimum wage. One of them, the tire pops on the car, you got to replace 4 tires, and it's like, oh.
There's a life event that happens, and
Which
for
is
whatever
always,
reason,
those
it
are
leads
always
to
the worst. Those are the ones that really
I gotcha.
they break your heart more than the other one.
Right.
Because you're like, you're here. What do we do? That eviction can get sealed, and I think that's really who it's helpful for.
Yeah, I got it.
I think the one-offs. Everybody says, "Oh, I can't believe people can seal evictions." I'm like, well, if you have 3 evictions, it's going to take you 15 years to seal all 3. So 10 to 15 years. So let's take a step back.
Right.
It's not gonna hide anything from anybody.
No.
It's really that one. It's really for the people who have that one. It's like the person who, when they were 20, minor in possession.
Right.
Same thing. You can expunge your record there. 22. You did something. You got
Isolated case, extenuating circumstances outside of the norm of their behavior, really isn't representative of who they are, their character, how they operate. And it's an opportunity. I mean, the spirit, I'm talking about the spirit of this, is really designed to help that person, not this repeat offender that's, I'm going to go live somewhere and, just dump and run, and then I'm going to do it again and again and again, because those people exist.
Think about it. You go to PC, right? And then all of a sudden you have a roommate who goes off the rails, doesn't pay his last for one of his last couple months of rent.
Sure.
The landlord knows he can get the money by filing a quick non-payment eviction. So he does it. Let's just say 40 years later, you want to go live at the 903s because you've had a successful career. You go to apply and they're like, hey, guess what? You have an eviction from when you were 21 years old.
Got it. Makes sense. Yeah, no, I get it. I mean, I understand from when I say makes sense, I understand the spirit of what's involved. We'll see how, it kind of plays out. At the end of the day, though, for a landlord that's, taking an applicant, going back to the whole application process, or a property management company that's running that application, it doesn't prevent that person or those persons from reaching out to prior landlord or prior landlords and talking to them specifically. And they may even, in the spirit of this law, say, listen, ended up having to evict, but here's the circumstances. Up until that point, they were a model citizen, but at the end of the day, they couldn't make that $4,000 rent payment, so I had to evict them. But from what I understand, from all of their payment history, they were great up until that point. And then that PM company or that landlord can make that decision. But it doesn't prevent that communication. At best, in an isolated basis, it seals the record for that one time for that resident under those with those circumstances.
Yep.
Okay. Self-help repairs. Limit was increased.
Let's start right here.
Yeah.
Let me jump in.
Please.
The number 125 was set in 1988. We are 36 years later, and we had our first increase in 36 years.
It's a little inflation.
Yeah. So basically, they looked at it as, we haven't done this in 35 years.
Right.
So we're going to bump it up to $500 because most repairs are somewhere between, $200 and $400.
I'm here to tell you the cost of a gallon of paint has gone up in that time.
So
considerably.
Yes.
Not arguing for this, but just saying, all right, so in the spirit of honoring
this isn't
inflation,
for Stonelink residents. Let's be honest.
Well, because so let's clarify. Really, this kicks in when a landlord or a property management company, whoever the agent is that's responsible for managing that property, doesn't take action
after getting written notice.
After getting written notice.
They still get 20 or 30 days to do the repair.
And so it's not like a tenant or a resident can wake up one morning and say, you know what, that hole in the wall just happened last night and I'm going to fix it. I'm not even going to contact the landlord. I'm not even going to let him know. And then I'm going to whack him with the bill.
Correct.
It doesn't apply in that situation. The same criteria apply where they have to get written notice. They get 20 or 30 days. And then if you really don't take action after all that time, yeah, they can take, then the self-help repair kicks in. Now it's $500 versus what was 125?
125.
Yeah, 125. So not a lot to talk about there. Really, if you're a landlord that's taking, action in a timely manner, if you're a property management company that, is taking action in a timely manner, you really shouldn't be affected by this.
Correct.
And by the way, here's a hot tip. The number one reason that your residents will move, statistically speaking, coast to coast, is poor maintenance. So here's more motivation to really get up on your maintenance and do a great job for your residents so you don't have to even deal with this issue. Back to you, Michael. So last one, and I think this is actually happening right now. There is the first draft, as it were, of the new consumer guide for landlords and tenants. And they are taking public comment, correct?
Correct. And I think it's going to mirror closely the landlord tenant handbook.
Right.
I don't think it's going to deviate much from it. We've seen it. I've read it. Not huge concerns. Remember, it's a guidebook.
Yeah.
It's a handbook.
It's not the law.
It's not the law.
Okay.
It's just what you can do in certain situations if you're a landlord.
Okay.
What you can do in certain situations if you're a tenant.
Okay.
And usually it's what can you do if it's more what can you do in certain situations if you're a tenant
Right.
than if you're a landlord, because the thinking behind the scenes is landlords have access to attorneys. They can afford attorneys, they can pay attorneys,
Sure.
and they get information from their attorneys. So that is why everybody looks at it and goes, why is this so skewed? That's probably why it's skewed. It's not, it's for that reason right there. But also, I mean, it's a handbook. You can open it, you can say, this is what I can do,
guidance.
this is what I can't do.
Yeah.
It's guidance. It's, it's usually kind of, if it's good practice,
Okay.
probably as well. We go back to, the repairs, making repairs, doing
Right.
those types of things. Really, it comes down to, if you're a landlord, are you taking care of your property
Mm-hmm.
and are you responding to your tenants? You've bought a business, whether you admit it or not.
Right.
We talk about this all the time with
This
property
is
management
not
companies.
mailbox money.
Correct. You bought a 2-3 family.
Right.
You bought it as an investment,
Right.
but that investment is also a business.
Right.
This isn't where you just handed money to a financial advisor and said, go
Right.
make 8% a year.
Right.
No, that's not happening here.
Right.
You have to actually babysit this business and run it, whether it's a single family home, a 3-family, a 6-family, whatever it is.
Right.
So you have to do the work. And if you don't want to do the work, then it's not the business for you, unfortunately. So it's guidance. Do the work. Just if you comply with it, it makes everybody's life easier. You probably will never meet me, which is great. I don't need to meet you.
No, you're a good guy.
Well, yeah, but you don't have to file cases with me. You don't have to pay me.
I got you.
You can just do it,
Yep.
whatever. And I tell people that. They say, well, you sound like, are you advocating for tenants? No, I'm just telling you how you can
This is how you
actually
navigate these waters.
run your business to where
Right.
you don't have to spend money that doesn't need to be spent.
So last question I have on this is, I think we've covered what the intent is. The comment period we're going to put in the description below for the video because it runs, I believe, through end of February. Don't quote me on that, please. We'll make sure to get that right. I know you've read through it. Doesn't sound like it's terribly materially different than the landlord tenant handbook that exists today. It's not where I'm going with this. Here's my question. When this thing gets finalized, ratified, stamped, approved, so on and so forth, based on your experience, 16 and a half years of doing this in Rhode Island, based on your experience, how have the courts interpreted the landlord tenant handbook that exists today? Do they reference it? Do they use it as a guide?
They don't reference it and they don't use it as a guide.
Okay, so there you go. This really is a guide. It's not law. The courts aren't looking at it as law. Historically speaking, based on your experience, they haven't looked at it as law. So it really is, it is kind of guidance, if you will.
And if a landlord or tenant is in a hearing or in front of a judge,
Right.
and uses the handbook as either a reference or a source. It's, well, the laws is this. This is where we're going with the law, and this is what it says. And, we need to abide with the law, not the handbook.
Got it. Great. Well, folks, I really appreciate you tuning in for this. Our second episode here with Michael Crane's done a tremendous job. This has been covering the 7 new laws that passed in the 2023 legislative session. If you have more questions, you can certainly reach out to us here at StoneLink Property Management. I'd also encourage you for legal advice to reach out to Michael Crane, law offices of Michael Crane. We will make sure to include his contact information in this video. And I'm just so grateful for the time, Michael, that you've spent here. It's been tremendous. So I want to give you the last word.
No, thanks for having me. Like I said, it's, there's 7 new laws. So they're going to be open to some interpretation. They're going to be open to, possibly ever changing, definitions and court decisions. So, we wait to see what's going to happen. As of right now, we'll proceed as to what the word of the law is. And if the definitions change, then we'll change what we're doing. So
sounds good.
Yeah.
There it is, folks. So if, again, you're interested and you have more questions, please reach out. Thanks for tuning in inside StoneLink, and we really appreciate your time and attention. Take care.